convening the meeting include authority, time, place, mode, serial number of the meeting and notice. Any director of the company may, at any time, summon a meeting of the board. The company secretary, or where there is no company secretary, any person authorized by the board in this behalf, on the requisition of a director, shall convene a meeting of the board in consultation with the chairman, or in his absence, the managing director, or in his absence, the whole-time director, where there is any, unless otherwise provided in the articles. Every meeting shall have a serial number. Meeting may be convened at any time and place, on any day, excluding a national holiday. Earlier in this module we have seen some rules for e-board meetings, so, considering the rules and facilities provided by the company, any director may participate in the meeting through technology or electronic mode. Remember that, there are certain acts and laws who specifically does not allow for any such virtual participation in the board meetings. Notice in writing of every meeting shall be given to every director by hand or by speed post or by registered post or by courier or by facsimile or by email or by any other electronic means. Notice shall be issued by the company secretary, or where there is no company secretary, any director, or any other person authorized by the board for the purpose. The notice shall specify the serial number, day, date, time, and full address of the venue of the meeting. In case the facility of participation through electronic mode is being made available, the notice shall inform the directors about the availability of such facility, and provide them necessary information to avail such facility. The notice of a meeting shall be given even if meetings are held on predetermined dates or at predetermined intervals. Notice convening a meeting shall be given at least 7 days before the date of the meeting, unless the articles prescribe a longer period. The agenda, setting out the business to be transacted at the meeting, and notes on agenda shall be given to the directors at least 7 days before the date of the meeting, unless the articles prescribe a longer period. Each item of business to be taken up at the meeting shall be serially numbered, and shall be supported by a note setting out the details of the proposal, relevant material facts that enable the directors to understand the meaning, scope, and implications of the proposal, and the nature of concern or interest, if any, of any director in the proposal, which the director had earlier disclosed. Any item not included in the agenda may be taken up for consideration with the permission of the chairman and with the consent of a majority of the directors present in the meeting, which shall include at least one independent director, if any. To transact urgent business, the notice, agenda, and notes on agenda may be given at shorter period of time than stated above, if at least one independent director, if any, shall be present at such meeting. If no independent director is present, decisions taken at such a meeting shall be circulated to all the directors and shall be final only on ratification thereof by at least one independent director, if any. In case the company does not have an independent director, the decisions shall be final only on ratification thereof by a majority of the directors of the company, unless such decisions were approved at the meeting itself by a majority of directors of the company. The board shall meet at least once in every calendar quarter, with a maximum interval of 120 days between any 2 consecutive meetings of the board, such that at least 4 meetings are held in each calendar year. The committees shall meet as often as necessary, subject to the minimum number and frequency stipulated by the board or as prescribed by any law or authority. Under certain acts, if company is required to appoint an independent director, then such director shall meet at least once in a calendar year. Quorum shall be present throughout the meeting. Quorum shall be present not only at the time of commencement of the meeting but also while transacting business. A director shall not be reckoned for quorum in respect of an item in which he is interested, and he shall not be present, whether physically or through electronic mode, during discussions and voting on such item. Directors participating through electronic mode in a meeting shall be counted for the purpose of quorum, unless they are to be excluded for any items of business under the provisions of the Act or any other law. The quorum for a meeting of the board shall be 1/3 of the total strength of the board, or 2 directors, whichever is higher. Where the number of directors is reduced below the minimum fixed by the articles, no business shall be transacted unless the number is first made up by the remaining director, or through a general meeting. The presence of all the members of any committee constituted by the board is necessary to form the quorum for meetings of such committee unless otherwise stipulated in the Act or any other law or the articles or by the board. Every company shall maintain separate attendance registers for the meetings of the board and meetings of the committee. The attendance register shall contain the following particulars: serial number and date of the meeting. In case of a committee meeting, name of the committee, place of the meeting, time of the meeting, names of the directors and signature of each director present, name and signature of the company secretary who is in attendance and also of persons attending the meeting by invitation. Every director, company secretary who is in attendance and every invitee who attends a meeting of the board or committee thereof shall sign the attendance register at that meeting. The attendance register shall be maintained at the registered office of the company or such other place as may be approved by the board. The attendance register is open for inspection by the directors. Entries in the attendance register shall be authenticated by the company secretary, or where there is no company secretary, by the chairman by appending his signature to each page. The attendance register shall be preserved for a period of at least 8 financial years and may be destroyed thereafter with the approval of the board. The attendance register shall be kept in the custody of the company secretary. Request for such leave has been received by the company secretary or by the chairman. For the board meetings, the chairman of the company shall be the chairman of the board. If the company does not have a chairman, the directors may elect one of themselves to be the chairman of the board. The chairman of the board shall conduct the meetings of the board. If no chairman is elected or if the chairman is unable to attend the meeting, the directors present at the meeting shall elect one of themselves to chair and conduct the meeting, unless otherwise provided in the articles. In case of meetings of committees, a member of the committee appointed by the board or elected by the committee as chairman of the committee, in accordance with the Act or any other law or the articles, shall conduct the meetings of the committee. If no chairman has been so elected or if the elected chairman is unable to attend the meeting, the committee shall elect one of its members present to chair and conduct the meeting of the committee, unless otherwise provided in the articles. Information about a particular click section. Click on each section to know more about it. The chairman of the board or in his absence, the managing director or in his absence, the whole-time director, and where there is none, any director other than an interested director, shall decide, before the draft resolution is circulated to all the directors, whether the approval of the board for a particular business shall be obtained by means of a resolution by circulation. Where not less than 1/3 of the total number of directors for the time being require the resolution under circulation to be decided at a meeting, the chairman shall put the resolution for consideration at a meeting of the board. A resolution proposed to be passed by circulation shall be sent in draft, together with the necessary papers, individually to all the directors including interested directors on the same day. The draft of the resolution to be passed and the necessary papers shall be circulated amongst the directors by hand, speed post, registered post, courier, email, etc. Provide with the explanatory note for each business proposal including details of proposal, relevant material facts, scope and implications of material, nature of concern, indication for assents or dissents, etc. The resolution is passed when it is approved by a majority of the directors entitled to vote on the resolution. The passed resolution shall be deemed to have been passed on the last date specified for signifying assent or dissent by the directors, or the date on which assent from more than 2/3 of the directors has been received. Resolutions passed by circulation shall be noted at the next meeting of the board, and the text thereof with dissent or abstention, if any, shall be recorded in the minutes of such. Passing of resolution by circulation shall be considered valid as if it had been passed at a duly convened meeting of the board. Minutes shall be recorded in books maintained for that purpose. A distinct minutes book shall be maintained for meetings of the board and each of its committees. Minutes may be maintained in electronic form in such manner as prescribed under the Act and as may be decided by the board. Minutes in electronic form shall be maintained with timestamp. The pages of the minutes books shall be consecutively numbered. Minutes shall not be pasted or attached to the minutes book, or tampered with in any manner. Minutes of the board meetings, if maintained in loose-leaf form, shall be bound periodically depending on the size and volume and coinciding with one or more financial years of the company. Minutes of the board meeting shall be kept at the registered office of the company or at such other place as may be approved by the board. General contents. Minutes shall state, at the beginning, the serial number and type of the meeting, name of the company, day, date, venue, and time of commencement and conclusion of the meeting. Minutes shall contain a fair and correct summary of the proceedings of the meeting. Minutes shall be written in clear, concise, and plain language. Any document, report, or notes placed before the board and referred to in the minutes shall be identified by initialing of such document, report, or notes by the company secretary or the chairman. Where any earlier resolution, or decision is superseded or modified, minutes shall contain a reference to such earlier resolution, or decision. Minutes of the preceding meeting shall be noted at a meeting of the board held immediately following the date of entry of such minutes in the minutes book. Days from the date of the conclusion of the meeting of the board or the committee, the draft minutes thereof shall be circulated by hand or by speed post or by registered post or by courier or by email or by any other recognized electronic means to all the members of the board or the committee for their comments. Minutes shall be entered in the minutes book within 30 days from the date of conclusion of the meeting. The date of entry of the minutes in the minutes book shall be recorded by the company secretary. Minutes, once entered in the minutes book, shall not be altered. Any alteration in the minutes as entered shall be made only by way of express approval of the board at its subsequent meeting in which such minutes are sought to be altered. Minutes of the meeting of the board shall be signed and dated by the chairman of the meeting or by the chairman of the next meeting. The chairman shall initial each page of the minutes, sign the last page and append to such signature the date on which and the place where he has signed the minutes. Minutes, once signed by the chairman, shall not be altered, save as mentioned in the standard. A copy of the signed minutes certified by the company secretary or where there is no company secretary, by any director authorized by the board shall be circulated to all directors within 15 days after these are signed. The minutes of meetings of the board and any committee thereof can be inspected by the directors. Extracts of the minutes shall be given only after the minutes have been duly entered in the minutes book. However, certified copies of any resolution passed at a meeting may be issued even earlier, if the text of that resolution had been placed at the meeting. Meetings shall be preserved permanently in physical or in electronic form with timestamp. Office copies of notices, agenda, notes on agenda and other related papers shall be preserved in good order in physical or in electronic form for as long as they remain current or for 8 financial years, whichever is later, and may be destroyed thereafter with the approval of the board. Minutes books shall be kept in the custody of the company secretary. The Number of the meeting of the board and committees. Dates of the meetings of the board and committees. Number of meetings attended by each director.